Mr. Foreman and ladies and gentlemen of the jury, this case in its trial has been a little more protracted than usual, as the jurymen must recognize, because of the unexpected attacks of illness on the part of one of the counsel. Both the counsel, members of the jury, are able and experienced. They have conducted this trial with commendable fairness and courtesy, not only to each other but to the court. They are what might be called friendly enemies. Each one has a wholesome respect for the ability of the other, and if at times there has been an interchange of pleasantries, you no doubt will understand that it was simply due to the enthusiasm which they naturally have for the protection of the interests of their respective clients. This is just preliminary to stating what has been emphasized by both counsel to you in the summation, in effect, that you are not bound by any statement of fact made by either of the learned counsel here in his summation to you, or by any statement of fact which might be alluded to by the court in this charge, unless such statements agree with your recollection of the testimony. Counsel have assured you that if you have any doubt whatever as to the testimony in this case, and will make such request known to the court through your foreman, the stenographer will be sent to you for your guidance to read such part of the evidence as you desire to have read to you. You must rely upon it, ladies and gentlemen, as both counsel have correctly informed you, that upon your own recollection of the testimony, and upon that alone, you must decide the issues involved in this case. Motions were made by the learned counsel for the defendant here to dismiss this case from your consideration. Those motions were denied by the court. You have nothing to do with their disposition whatever. Why were they denied? Simply and solely because from the evidence in this case, the court was of the opinion that opinions of fact were presented which you gentlemen should be called upon to consider and determine. That is all. Now, what are those questions of fact? Before these plaintiffs can recover here in these cases, you must find in the first place that the accident, unfortunate as it was, happened substantially as claimed by the plaintiffs. You must find that at the time of this occurrence, the plaintiff was driving his car in an easterly direction and had practically crossed Madison Avenue when the rear end on the right-hand side of his car was struck by the northbound car owned and operated by the defendant. If you find that is not the way it happened, and that at that time this plaintiff was driving his car downtown and then turned into 120th Street, of course the plaintiffs would not be entitled to recover because the accident would not have happened substantially as claimed by the plaintiffs. That, of course, would be the first question that might present itself to you in your deliberations as jurymen. If you find that the accident happened substantially as claimed by the plaintiffs, you have two questions of fact here to determine, and both of these questions of fact, before there can be any recovery, must be established by the plaintiffs by a fair preponderance of the credible testimony, which does not mean that they must be established by the greater number of witnesses, but by the character and quality of their testimony, because evidence must be weighed, ladies and gentlemen, and not counted. And all of these questions of fact, the plaintiffs have the burden of proof. In other words, they must be established by the plaintiffs before there can be any recovery by more believable, more credible, more convincing testimony than that in which the defendant has established the evidence. And of course, there can be no recovery for the plaintiffs, because in such event, the plaintiffs would not have sustained the burden of proof cast upon them by law. Now, gentlemen and ladies, before there can be any recovery, these are the two questions of fact which must be established by these plaintiffs. First, that the plaintiffs were not guilty of any negligence which contributed in the slightest degree to the accident. Were these plaintiffs negligent? If so, in what respect? What did they fail to do that they should have done? As reasonably prudent persons under similar circumstances, or what did they do that such persons would not have done? And if they omitted to do anything or did something which reasonably prudent persons were charged with the obligation of omitting to do or of doing under some similar circumstances, did that contribute to the accident? If you find that these plaintiffs were guilty of any negligence which contributed to this accident,